Welcome. I'm attorney Brandon Thomson here at the Elder Care Firm. I'm starting a new video series called The 10 Most Gruesome Estate Planning Mistakes. Today I'm going to start with mistake number 1. It's called dying intestate. I know that's sort of a weird word, but if you die intestate, that simply means that you have died without a valid will. And if you die without a valid will, or haven't planned otherwise, and you have some assets still left in your name, the only way to pass that property on to the next generation or your beneficiaries is through the probate court. Now, when you go to probate in this situation, you don't have a will, so there are no instructions to the probate court. So how is your property going to be passed? Well, there's a code called the EPIC code. It's a big government rule book, and it's going to pass your property according to their rules. Most of our clients want to avoid this situation. They want to minimize taxes, control distribution of their property, and also probate court is a public hearing. It's a public case, so anybody can come in and check out who's getting what and contest it. Now, there are 4 ways to pass property at your death. 4 typical ways. First way is through joint property designations. So you own property together with somebody, say husband and wife, they own a home together. Husband dies, property goes to the wife. There's no probate, it's pretty simple. The second way is through beneficiary designations. You have your IRA, 401k, life insurance. These are pretty simple. You name a beneficiary during your life. When you die, that property is going to pass on to your beneficiary. No need for probate. The third way is through a trust. If you put a trust together and you fund it properly, and by funding I mean you've titled all of your assets into your trust, then that property will pass on to the next generation outside of the probate court. But unfortunately, what we've seen here a lot at the Elder Care Firm is that when trusts are drafted, a lot of times the property isn't titled properly into that trust, and you end up in probate anyway. And the fourth way to pass your assets on to the next generation, if you haven't used any of the 3 ones that I've named so far, joint property, beneficiary designation, or a trust, is through the probate court. A lot of our clients want to avoid the probate court, and we recommend it because probate can be very expensive. The AARP has said that 5 to 20% of your estate amount will be paid to the probate court. It's a public hearing. Anybody can come and challenge it. It's also very time consuming. By statute, it's 5 months at a minimum. So mistake number 1 is dying intestate. We say that it's a good idea to avoid this for the reasons that I've named. Again, it's Brandon Thomson at the Elder Care Firm. Thank you.